Hi, everyone. It's really, really great to see so many people here from so many different countries. I think it really shows how important this topic is in all of our different contexts. Even though the contexts are different, there's still a lot that we share. The amount of repression we see from the state and governmental institution and the police is just increasing so much in the last years when it comes to different climate activism or human rights activism, now around the pro-Palestinian solidarity activism. And it's really important for us to have the knowledge to hear also what's happening elsewhere, to be able to share this experience and learn from each other and support each other and build solidarity. So we are really hoping that this webinar will be one step in this direction. I get so into the topic. Hi, my name is Barbara. I'm one of the co-organizers of the webinar. I'm part of the Movement Hub team. We've been supporting different climate justice movements and social movements from 2020 and from, I think in the last 1.5 years, we've been focusing more on anti-repression work. We started a platform, a non-formal platform community of law legal practitioners around Europe. It's called Legally Green. And to people who are also working or interested in this area, it's open. Just let us know if you're interested in joining. And we've been also doing some anti-repression workshops for different groups and in different climate camps and similar spaces. Last year, we started talking with people from Amnesty. We've been sharing what we hear about different repressions and different cases of repressions toward activists. And we also learned about the report they've been working on. And then we also got together with Charlie from Global Climate Legal Defense to see how they are supporting different activists. And we decided to organize this webinar to kind of bring more attention to these topics and to different trends that we are seeing across Europe, and also to learn what we can do about that. And I'm super happy that the three great people accepted this invitation for the webinar. So it's Catrinel Motoc from Amnesty International. Hi, Kat. There's Zoe from the Swiss Collective Climate Justice Legal Team, and there's Charlie Holt from the Global Climate Legal Defense. Just a few words on how this will go today. Each of our speakers will have around 10 minutes input, sharing what they do in their work. And afterwards, there will be time for your questions. There is a Q&A function that you can use. You should see that in the bottom of your screen, I believe. And then there is also a chat open if you want to share anything else, any remarks and so on. I would just like to ask everyone to be respectful and mindful of language in the chat. It's our common space. The webinar will be recorded, and then we would like to have some materials from that. So just so you know that there will be a chance to come back to some parts of it. And I believe that is all. Yes, just a small reminder, there's Carl and Gabriela in the room doing the tech support. So if there's anything you are struggling with, please write to them in the chat and they will try to help you. And without any further ado, I would pass on the words to Kat.
Thank you, Barbara, and hi everyone. I'm very pleased to be here today. So thank you for the opportunity to actually speak about the work that we've been doing on the right to protest. I'll be speaking today, however, the work that I'll refer to, it's been done by an amazing team, and I have great colleagues with whom I work together. So it's everything that you'll hear today, for the good and for the bad, is the result of a teamwork. So Amnesty in July 2022, so almost 2 years ago, has launched a global campaign called Protect the Protest. Obviously, we arrived at the moment of launching this campaign 2 years ago, but the issue has been very much alive and very much under threat for many, many, many years. And also before that, we have done quite a lot of work across a number of countries. However, 2 years ago, we have decided to elevate this to a global priority. And that means that actually there is the conscious decision of the organization to campaign for the protection of the right to protest. And at the time, it seemed a very topical issue, but now it seems even more topical because of the restrictions and the oppression that we have been seeing across Europe, but also beyond that. When we have launched the campaign, we actually had 3 key objectives in mind. And I'll very briefly mention them because I think it gives an idea of the various dimensions through which we'll be working. First of all, the idea was to try to expose and challenge the various barriers or violations of the right to protest that happen in different settings and in different manner across several countries across the world. But it goes from excessive policing to repressive legislation, different ways, but also with a very specific focus on gendered, racialized, or identity-based discrimination practices that we have seen. The second objective that we had in mind was to actually collaborate and act in solidarity with different people movements across the world, because together we're stronger and together we are actually able to resist the level of oppression and restrictions that we have seen. And ultimately, the third key areas that we wanted to focus on was to create a positive narrative. I think we've all seen the smearing, the stigmatizing, the delegitimizing narrative that we see on protest and protesters and the causes for which we rightfully protest. And the idea was to actually counter that and celebrate protest as a right and not as a privilege, as oftentimes that's being portrayed by state and non-state authorities. After the launch of the global campaign, together with several colleagues, we have come up with an idea of actually doing an overview as complete as we were able to of the state of play of the right to protest across Europe. Obviously, Europe has many, many, many countries, and we're not that many. So at the moment, we're actually working on a report, which is supposed to be launched on the 9th of July, which does a overview and takes stock of the state of play of the right to protest in 21 countries. So not all of them, but also not a very minute number of countries. And the idea was that we wanted to understand where exactly the right to protest is or isn't, what types of restrictions are being put in different countries or on specific groups. And the idea was to also scrutinize what states are doing or not doing, oftentimes, when it comes to the protection and facilitation of the right to protest. But also, we wanted to create a baseline that in the next few years would allow us to be able to say or see whether there is a regression or progression when it comes to guaranteeing the right to protest. I'm speaking, in a few sentences of what actually has been the last 1.5 years of work, and we're also very happy for when this report is going to finally see the light. Like I said, it's on the 9th of July. But as part of this report, what we actually have been able to do is, besides the analysis of various provisions in the laws and policies or practices in these 21 countries, which, by the way, they cover Western Europe, Eastern Europe, and also a country in the Balkans. So we tried to balance it geographically. We managed to identify several regional key trends. Some of them, we already had a hunch that they existed because of the things that we were observing. But now we'll actually be able to have the data that backs up some of this, unfortunately, not very positive regional trends. And we'll put them in the chat so you have an idea of the very short summaries of each and every one of them. However, today I wanted to just focus on 3 or 4 of them in a quite quick succession. But obviously, I'll invite you, when the report is out, it's a 200 pages report, so it's quite a lengthy read. Many details are gonna be put there. So one of the first trends that we have identified, and I very briefly referred to it, is that protest is treated as a threat. Generally, is presented as a privilege and not as a right, which we all actually do have, and states are supposed to put it in place and protect it. And very often, public security is actually used as a justification either to curtail protests or to delegitimize some of the causes that we're protesting on. And this approach of treating protest as a threat generally has led to a very zero tolerance approach, which means very little or almost no tolerance when it comes to disruption. Introduction of really severe draconian legislation or maintenance of legislation, which is then weaponized and used against protesters. We have seen in a number of countries very heavy policing and extensive excessive use of force, which lends itself, to injuries, to quite serious harm being done to peaceful protesters. But also we have seen issues such as arrest, arbitrary arrest, and surveillance. And this overall approach and treatment of protest as a threat, it's putting all of us in what is called in a legal terms chilling effect, but basically we all fear or we all have to think twice what are the consequences that we would face the moment we go and take the streets. And obviously different countries have different approaches, but we see generally a tendency for things getting worse and the treatment of protesters becoming worse and worse across the region. A second unfortunate regional trend that we have identified is that while the restrictions on protest happen across all the countries, different groups are affected disproportionately or discriminatorily. And we have seen, it depends very much on a country by country, but generally we have seen attacks on climate protesters, pro-Palestinian solidarity, women's rights, LGBTI activists, children in some countries, elderly people, people with disabilities, sex workers, but also a disparity of treatment between who is a citizen, who is not a citizen in certain countries. And generally, we have seen quite stigmatizing and delegitimizing smearing rhetoric against certain groups. Again, as I said, it depends a little bit country by country, but generally across the region, we have seen this. And at the same time, there's not a lot of attention purposefully for the root causes of why the protests are happening. But actually, that's also happening because in many countries, we see either an inadequate or fragmented anti-discrimination legislation, racism, prejudice, and like I said, the first kind of key trend, protest is seen as a threat and is treated as a threat. Thirdly, unfortunately, we have seen a number of evidence of cases and practices and policies of really excessive and heavy-handed policing. Probably all of us at some point have been able to witness that, but it's actually taking us quite back, having a bit of a bird's view perspective across the region. Generally, the way we are able to explain this unfortunate trend is there is a tendency towards militarization and secretization of policing. States do not see or perceive their obligation to facilitate, but is very much an us versus them approach, rather than looking at protest as a legitimate form of expression, a right that people have and should be able to exercise. It's on the contrary, protesters are depicted, and we have a whole chapter in the report, as rioters, terrorists, disturbing public order. So it's a type of rhetoric that actually fuels hostility, but also justifies very punitive approaches that we have seen across the countries. And more specifically, we have seen use of specific equipment or weapons that shouldn't have a place in a peaceful protest, that leads to injuries and harm towards a lot of the people participating. And obviously, when you think about people with disabilities or children or elderly or people with various aspects in their life that make them even more vulnerable in situations that become quite dangerous because of the way policing of protests is being done across the region. And unfortunately, coupled with that excessive and heavy-handed policing, we have seen a very prevalent lack of accountability, be that there are not mechanisms in place to actually investigate and punish when violations are being done by law enforcement. But also in some countries, we have seen, for example, the simple thing of having an identity badge on the law enforcement is not present. Therefore, it becomes even more hard, even harder to actually hold them to account. And lastly, one, like I said, I'm not going to go into details of all 10 of them because otherwise we'll be here until tomorrow. But the fourth key trend that I would like to focus on is the existence of repressive legislation. Every single country among the 21 that we have looked at do codify the right to protest, which for us is a shortcut between, the right to freedom of peaceful assembly, freedom of expression, freedom of association. They do codify it. However, in practice, we have seen various attempts to control or to suppress dissent, either by introducing usually quite fast-paced regressive legislation, or using and weaponizing existing legislation to actually bring administrative or criminal sanctions against protesters that actually do act or carry out behaviors which are protected. In practice, how this plays out, we have seen there is a mix between among various countries having mandatory notification or authorization regimes. There is only one country in Ireland where we have seen it's a voluntary process. And usually this is done in a very punitive way, in the sense that the process and the regulations are used as an end in itself. They're used to control rather than facilitate. And for example, authorization regimes, in the sense that you have to be given permission by the state to protest. We have seen them in Sweden, in Belgium. They're introducing in Luxembourg and in Switzerland. But also the mandatory notification present in some other countries have some requirements. For example, in Turkey, in order to do a protest, if you're a foreigner, you need to ask specific authorization. Or you have to disclose your criminal record. Or in Switzerland, if you want to do a protest, which is happening less than 30 days from the day that you actually seek authorization, you have to pay for a fee. Or otherwise, we have seen restrictions on what is called time, place, and content. For example, in Belgium, there are specific areas in certain cities where you're not allowed to protest, ever. And that is contrary to international human rights law. Or a very big chunk of this regressive legislation that we looked at is excessive liabilities and obligation on organizers, be that to pay for cleaning, secure stewarding, being liable for actions done by others with whom you have never had anything to do, but they happen to participate in your protest. So quite an excessive range of liabilities that go beyond anything that international human rights law would allow. Or we have seen, for example, provisions where certain assemblies are privileged towards others. In Poland, there is a provision around what's called a cyclical assembly. So actually there, oftentimes it has happened that pro-government assemblies were getting a preferential treatment. And ultimately, and I'm going to end here, we have seen in several countries in the last few years, several legislation being brought in. To give you an example, in Luxembourg at the moment, there is a public consultation. Well, there's a consultation. Actually, I'm not 100% sure if it's public anymore, on the new legislation around assemblies, and is very regressive. Is actually taking the country 1, 2, 3 steps back. Equally, Italy has seen new legislation being brought in with the so-called justification of the eco-vandals. The rhetoric itself and the way the legislation is being spoken to, it's quite telling on what exactly it's going to tackle and how the states are treating protesters. But equally, we have seen in Belgium, for example, the recent review of the criminal code has introduced a type of new offense, which is similar to sedition, and that also is very problematic. And unfortunately, I'm not able to go into a lot of details as of yet, but the number of bad practices that we have seen across the region is quite telling. And when I talk about international human rights law, I talk both about the European standards, but also about the international, like the UN, the General Comment, the ICCPR, the key foundations of international law. And then in Europe, Fortunately, we do have jurisprudence and we have the convention. However, that's not always the case in other countries. I'll stop here, but also obviously I'm able to take some questions and also add a bit more details. But for the sake of giving space to all the panelists, I'll stop here for now. And thank you so much.
Thank you, Kat, so much for your input, and thanks to everyone who's contributing in the chat. If you have a specific question, please do put it into the Q&A section so it's easy for all the panelists to see, because things can get lost in the chat. And yeah, if you have any questions to Kat, please put them in the Q&A. We also put all the key 10 trends that Kat shared into a pad with some more links, and we will share the pad so you can also copy that further. And now I would like to give the word to Charlie. Hi, Charlie.
Hi, everyone. And I need to start with an apology, which is that I was off screen for a bit there because I seem to be having some laptop issues, which I thought were Wi-Fi issues, and they seem to be laptop issues. So I'm very much hoping my laptop is going to survive this, but I do apologize if there's any interruption. I'm also going to start the perilous exercise of trying to share my screen. And thanks to the tech support here, I hopefully will be able to do so easily enough. But it would be great to hear whether or not that's working there. Is that working?
We're seeing your notes currently, Charlie. There you go. That works.
Fantastic. Thank you very much, Carl. So, hello, everyone. It's a real pleasure to be here today. I work for an organization called CliDef. We work to, our aim is to embolden climate defenders to take confrontational action without the fear of legal response, of heavy-handed legal response. So we really work to counter both threats to climate activism and to counter the chilling effect that is being created by many of the repressive trends that Kat's already spoken about. I wanted to start just by explaining a bit about CliDef, because I think it will help to contextualize the rest of my presentation. We support climate defenders, that's broadly defined, and can include a range of different actors, not just activists, but also whistleblowers, for example, journalists in some situations, and so on. But my perspective is very much coming from the escalating threats to climate activism we've seen, much of which will echo what Kat has already said, but I hope will also take a fairly different perspective. So I'll just start here. So the work of CliDef is, I should emphasize, outcome driven. So we don't so much have a single model that we roll out in different countries in which we operate. Rather, what we do is to first build up an understanding of the particular circumstances in different countries and then adapt our approach accordingly. So in every country in which we operate, we are just focused on the outcome, and that outcome being to ensure that every climate activist have the support they need. So we focus on certain priority countries, which we identify using three main criteria. First of all, we look at political and legal conditions in a country. Secondly, we look at the contribution to the climate crisis of that country. And finally, we look at the potential impact of our intervention. For the latter, we look at both the state of the climate movement in that country and the extent to which systems of support exist to respond to legal threats. So what exactly our intervention looks like will depend on the precise conditions in that country. So it may involve us building up new systems of support in conjunction with local partners, but more often it involves strengthening existing systems through, say, financial support and also just providing advice. But I emphasize that because for most of the cases we'll be talking about, that support does exist, and we've just been working to strengthen and build that up. We're constantly reviewing trends and developments in the way. So my focus has been on Europe, and I've been tracking trends here for the last 18 months. Many of the trends we have seen echo those identified already by Kat, and I don't want to repeat what has already been said. What I will note is that in many countries, what we've seen is a convergence of threats from three different actors, from the government, from private actors, and from the judiciary. And this together forms what has been termed by a lawyer here in the UK, Michael Mansfield, the pincer movement. It's each of these actors are pursuing the same overarching objective, which is to chill or to deter protest activity, but they're all doing it in different ways and happening at the same time. So just to go through these points, and again, I don't want to repeat what has already been said by Cad, but I will just emphasize here, when it comes from the government, we're talking about a wave of new laws, as Kat said at the end of her presentation. We've seen that, for example, in France, Germany, Spain, Italy, Hungary, Poland, and so on, all of which are strengthening police powers to restrict or shut down protest. But we've also seen old laws being stretched to apply to peaceful protest. We saw this during last year's European Gas Conference in Vienna, but I think perhaps the best example is the law currently being used in Germany against last generation activists, against the formation of a criminal organization. Again, that's a very old law which is being refashioned as a weapon against activism. Secondly, we have private parties. This is most obviously seen in the growth of SLAP, strategic lawsuits against public participation, which have become more prolific against activists, but I would note also have become more shameless. This, I think, is itself a product of polarization, which makes it easier for corporations and individual actors to vilify and discredit activists, and therefore just create some justification for their attack. I think a few years ago, the fact that large fossil fuel companies such as Total Energies, Shell, and Eni are now filing these large-scale lawsuits against climate activists would have been less thinkable, would have been unthinkable a few years ago, and now has become a real problem. One thing we've seen grow in the UK has been the use of far-reaching injunctions against so-called persons unknown. So injunctions which have essentially have the result of criminalizing protest activity, but aren't targeted against any individuals who are notified, but rather targeting a huge number of anonymous and unknown actors. And this has been a huge problem that we've seen here. And finally, the judiciary. So here in the UK, we've seen a much greater willingness to use prison sentences against climate activists. Again, a few years ago, that would have been unthinkable. Now we have a situation where Just Stop Oil alone has seen 138 people spend time in prison since 2022. This can be attributed in part to the decision to imprison a few years ago Morgan Trowland and Marcus Decker, two activists with Just Stop Oil, for 3 years and 2 years and 7 months, respectively, which has essentially given license to lower courts to apply such prison sentences. I think, to be clear, I'm not saying this is some vast deep state conspiracy. It's more a coincidence of intersecting interests. So the judiciary in England and Wales, for example, and I've seen this elsewhere as well, has repeatedly invoked the need for deterrence when handing down heavy-handed sentences. It's hard to see how this doesn't itself represent politicization of the judiciary. And I think it's particularly galling given the reluctance of courts to take the climate crisis seriously, but that's another matter. It's also true that the judiciary has been tightening its approach in response to certain government initiatives. Again, here in the UK, we saw the removal of a defence of consent in the context of criminal damage following an application made by the government. The overall result of this is a pressure, unprecedented pressure being applied on climate activists coming from 3 different places at once, which can cause a huge pressure and, of course, advance the chilling effect, which all 3 actors are trying to create. The other thing I think it's important to note is the extent to which governments and private actors, at least, are learning from each other. We certainly see so-called playbooks being popularized across Europe. And I think one example of this is the growing focus on organizational liability, with governments across Europe finding ways to target those who are organizing protests and holding them liable for offences committed by individual members of those groups. And there's, I think, 3 different examples we've seen. First of all, I think we're probably familiar with the investigation and now charges brought against members of Last Generation in Germany. But we saw Spanish police in January detaining climate activists on the basis of forming a criminal structure with their group Futuro Vegetal. You can see a picture there. Secondly, the use of incitement laws, or at least using incitement as a pretext for then taking measures against climate groups. Les Soulèvements de la Terre, the French group, and I do apologize to any French speakers, my pronunciation is terrible, but the decision of the French government to dissolve that group was on the basis of alleged incitement. And we have more recent, and then 2022, we also saw incitement laws being used against organizers of protests in the Netherlands. I've added conspiracy here, not so much because there's been that same trend, but there have been a couple of examples where conspiracy charges have been brought against activists in the UK and in Italy on the basis of, future planned, alleged future planned offences. The photo there is of Gail Bradbook, who's one of the co-founders of Extinction Rebellion, who had conspiracy charges ultimately dropped against her, but only after having her laptop seized and her house raided. So I mention this because we can, to some extent, anticipate where new legal threats are likely to emerge. Climate activists in Germany, for example, have a wealth of experience now about reducing exposure to organizational liability, which unfortunately many of us are all going to have to learn about in other countries. And I think this is why Legally Green has been so important, and one that I hope will continue. Now, the climate movement is still relatively young in many parts of Europe, and governments in certain countries where the rule of law has been in decline, like in Turkey and Poland, for example, have not yet caught up. And I think that's another important thing too. In those countries where the movement is younger, they can learn from the experience of those in countries with more established movements and about how governments have been responding as a means of understanding what is likely to come down the horizon. And very briefly, and then I will give way because I realize my time is there, I just wanted to go with some of the best practices that we've seen, or some of the learnings. Again, I should emphasize there is no single model for responding to escalating threats. The common thread of all those movements with effective support mechanisms is their ability to join forces, consolidate support, and establish single points of contact for support and strategy coordination. The more fragmented and individualistic approaches tend to be more problematic. So one of the problems we've seen in some parts of Europe has been where there's been a great reliance on self-representation, which can cause problems then for the movement as a whole. And similar problems arise where there are mass arrests or mass charges being brought, but with no single point of coordination, which makes it very difficult to then formulate movement-wide strategy. But beyond that, as long as you've got those pieces in place, response mechanisms take a range of different forms. I see we've got Zoe coming next. I put here one of the points there about self-organizing legal networks, which is something that we've seen in Switzerland with Avocat pour le Climat. Again, apologies for my pronunciation. But in other countries, we've seen individual groups within the climate movement taking a lead role to provide support, which really works because those groups are trusted and are able to assume a role on behalf of the movement. I put 2 examples there. RATS is a new group which has been formed in Germany, but has come out of the experience of Last Generation and the need for support there. And finally, and this is what I'll end with, is there's been the use of coalition structures. We've seen coalition structures emerge in Italy. I've put there a logo of Indefesa D. Which has again been, I think, is an interesting way to ensure that cohesion and that coordination. And in other coalitions too. I mean, I've put here just because I think there are learnings to take from this. The Coalition Against Slaps in Europe, or CASE, on which I sit on the steering committee, and that's because coalitions can play a really important role, not just in providing legal support, but also in providing, or rather encountering some of the smear campaigns that we're seeing against climate activists. And I think this is really important because it's the facade of legitimacy which props up attacks on protest rights, on freedom of expression. So it's much easier for whether it's governments or private actors or indeed the judiciary to clamp down on climate activists when they can present those activists as being members of a rogue eco-terrorist group, if they're able to marginalize them and isolate them from broader civil society. So the importance of coalitions, and this is something we've seen from CASE, is the ability to be able to counteract that. So CASE, it was set up a few years ago, now has 117 members. And part of the purpose of projecting solidarity through CASE is to be able to counteract those efforts to isolate and to marginalize. So I think there are learnings there as well, more broadly in civil society, about how best to respond. But I will close now and just give a few conclusions. And I would just end by saying those points. First of all, that importance of solidarity, having that, even if you don't have a formal coalition in place, being able to coordinate and ensure that you are saying and amplifying the same messaging is really important. Secondly, the need for a single point of contact for strategic oversight and coordination. That I think is really important to ensure that no individual defense is undermining the movement as a whole, and also important for fundraising when you can show that there is that overarching strategy being pursued. And finally, adaptability. I think the best way to respond to efforts to shut down criticism is with creativity and adaptability. And again, this is where it's so important that we learn from each other, because many groups in our broader network, many of the groups who attend the Legally Green calls hosted by the Movement Hub are able to share experiences of how they've been able to adapt their activism in a way which hasn't reduced the efficacy, but which has been able to navigate around some of the new legal obstacles which have been created. And I will end on that note. Thank you so much.
Thank you so much, Charlie, also with bringing us to what we can do and how we can do it together. And now I would like to pass the word to Zoe from the Collective Climate Justice Legal Team.
Yes, thanks very much as well from my side for the invitation to this webinar. I also will try to show my slides in a second if I manage to. Oh, now I hope you can see my slides. Yes, I see people nodding, which is great. So yes, I was invited to give a short perspective on how that so-called self-organizing legal team work could look like. And I might start with a very short introduction to my background. As said before, I'm based in Switzerland. I do not have any kind of professional legal background, but some years of experience within those self-organized grassroots groups doing legal work. I'm mostly organized within those grassroots groups, but we are also very often in contact or close connection to different NGOs, and as well in this networked kind of way with other legal teams and other grassroots groups. We are no fixed legal team for everyone, providing like some sort of general service, but rather for different projects, campaigns, and actions. And some of us are involved in other cases and campaigns as well as in a loose network of legal teams throughout the country. And furthermore regarding the network sense, not regarding contributing to legal work. Yes, I will take you for my short presentation through like a hypothetical action which happens and bring in some points of what to think about, what to discuss, and what might be feasible or needed to have in mind when doing this work. And I'm also very eager to say that there's, I think, in my view, no fixed way to do this kind of things. There is no rule book which you can read and then just follow. And I really like to point out what Charlie said before, that you need to be adaptive to the special context you're active in. But before starting as a group, I think some general thoughts are helpful. At first is like, why? Do we want to be a group which provides this general service to the movement, or are we like more project specific and are doing this for one single action or campaign? Then who are we? Which expertise can we bring in? What might be missing? Whom do we need to ask to contribute to our team to be able to fulfill our responsibility we give ourselves? What exactly that? What do we feel responsible for? What not? Do we see ourselves as just providing the legal support for activists in a certain action, or are we also responsible for the whole campaign, for a possible legal follow-up and the whole fundraising, or not? And when? What is the duration we can offer to be working on a project? How are our own capacities? And which strategy are we following? What are we fighting for? I will be a bit more precise on that on a later slide. Well, before an action as a team, in most cases, you are responsible to make an assessment of the legal risks which are present, which torts, meaning which offenses can be faced by the activists, which special circumstances do we have. Look at the action plan itself, as far as you know it, how many people will be involved, are there foreigners expected to join us? Legally, they might be treated differently. Are there minors expected to join children? Which strategies and tactics do the activists want to use? And is there maybe an action consensus where you can already think, okay, those offenses might be possible, or they might really not be possible, as the activists, for example, say they really do not want to commit any damage of property. Maybe if you have the time and capacities beforehand, already discuss the legal strategy. Do you want to go to court anyway, or are you making this dependent on the threats that people are facing? And also try to contacting lawyers in beforehand. Attention, not always only criminal law is needed. Sometimes you always also need administrative law. And also maybe talk a bit about logistics, where you will be, how you will be able to communicate with the action people, and on kind of which shift plan or logistical means are you acting. Regarding the activists, what do you want to bring up to their minds in beforehand? You might be wanting to explain the legal risks in terms of direct repression, which financial consequences are to be accepted or expected, the criminal record entry regarding consequences of the residency status, and also maybe name then the worst case scenario which might be happening. Given general legal briefing, what's important if you're facing the police, maybe write this down, maybe make, if it's a minor amount of people in the action, make a contact list, inform about the legal strategy if you already have it, and also in most of the cases, hand out a number, and maybe if it's feasible, a lawyer's name and number, and be ready to answer questions. Exactly. During the action, most of the time, one of your most important tasks to do is answering that phone number you handed out to people. Try to also stay in contact with your lawyers, inform them about what's happening, what might be threatened to the people taking action on the street. Stay in contact also with the action team who's coordinating the action, who is in the action, and all your communications, as they probably want to know what's happening on the legal side. Coordinate with child support teams. Maybe we'll try to do some sort of protocol logging the event of the actions. Involve the lawyers as soon as pre-trial detention is threatened, is something I know from most countries, which is really needed, as then your capacities as a volunteer legal team end. And maybe if you have made that list of contacts, next of kins, or other important contacts of the activists, if you can see, okay, this might be taking a bit longer than expected. What happens directly after an action? What I feel is very important, and also, or very often gets missed, is to empower the activists to write memory protocols and maybe get medical testimonies of police violence. Very important. And as Charlie mentioned regarding that single point of contact, ensure everyone knows what to do when they get a letter by the state's attorney, by the police, by whomever regarding legal follow-up of the action. check if immediate legal measurements need to be taken regarding objections against DNA samplings, power of attorney, if you already know someone will need further support, and organize this. Make sure there are places to go for psychological support. Often people are much concerned about the legal consequences and they go to the legal team first, and you realize, okay, this person needs also support in other areas. We need to make sure that someone is not be left alone in different kind of ways. And also empower affinity groups to do debriefings of their own. Again, as in beforehand, be ready to answer a bunch of questions, and if needed, organize support structures for people who are staying in police custody longer or even in pre-trial detention. What happens directly after an action as your legal team? I strongly encourage to do a debrief and check how are we going to continue our work. Is every one of us still part of the team, or are people leaving and some just take over the tasks of the follow-up? Make sure that you have someone answering that single point of contact, most of the time an email, staying in contact with the lawyers you already have engaged in your campaign, and define what happens when the first letters arrive. Mostly that's going to be a meeting, but maybe you want to call for a wider or more open meeting, sometimes just in your legal team. And also, I strongly recommend to stay in contact with the whole group or political movement behind a certain action or campaign regarding further fundraising and communication efforts. Then what to do when the first letters arrive? Have a look at them, assess the content. Is this something we expected, or are there really unexpected things written there? Get back to your lawyers again, discuss with them, what do they think, what's their assessment? Maybe they also might be able to give a hint of how successful a further fight against the things will be, and try to contact all potentially affected activists and contact the group who was or is behind the action or campaign. Maybe they won't use this fact that the state is taking repressive measures again as a next campaign movement. And the latest here, start to discuss and define strategy. And yes, regarding strategy, I think that may be one of my most important slides, or the most important things I want to say. Regarding strategy, I made the experience is very important to maybe decide beforehand who's going to decide on the strategy. Are it solely the people affected by the repression? Is it the people affected together with the people willing to support them? Or is it as well the people affected, the people willing to support them, and the people who were bringing the action on the streets in advance, or even all together? And I saw in the last year roughly 3 different strategy options, and they're non-exhaustive. I'm sure there are more. First would be going to court as a political tool. You want to use that stage again to talk about the campaign content. Maybe you want to try to establish a new discourse regarding climate necessity, or you want to highlight crimes of a company we're attacking with the action. Going to court as a strategic tool. You have some new police law you think is against European human rights law. You want to change that, fight it against the European Court of Human Rights. Or you want to set a positive precedent. There are different options. And there's also, and also very often, going to court as a pragmatic decision. You try to reduce sentences for individuals or get accusations for different offenses. And yes, also sometimes something to think about, are there further options beside the criminal proceedings? Is there the option for an out-of-court settlement if no one really has the capacities of doing a political campaign or political trial out of this? I think at least things to think about, even if they spark a lot of discussions most of the time. And I think for me, the most important takeaway from that is as well that solidarity rocks. In my kind of perspective, that's the most important task of such a legal team group. Make sure that no one's being left alone with the consequences of repression. and to be in a networked way together with a wider perspective of the country you're in, as well as maybe European-wide or globally, to show solidarity to the people who are fighting for their rights on the street, and to support them in continuing to do that. And the picture is just from an online solidarity campaign during the COVID pandemic, where we were really positively surprised how many people were willing to support activists of a court case. Yes, regarding legal follow-up, you can read it there. There are different roles and tasks to take up: contact with activists, lawyers, team and campaigns, collect all the information you took during the action, and prepare the proceedings to come, being it police interviews or prepare the court hearings. And also, as like a big package beside that, really pragmatic and logical things you need to take care in the daily business, is also the campaign aspect. If you choose to go to court, not only due to pragmatic reasons, that you use it, that you are in touch with all the media and communication, that you do the fundraising so you'll be able to do the campaign. Also discuss how you will distribute the fundraising and stay in contact with similar campaigns and activate your network, also pointing out the Legally Green network here. And really be aware that this work, the action might take 2 hours, but the legal work might take 10 years. So really be prepared for the long run there. Yeah, that's a picture of such a court hearing. I think here it's mostly what I've already said. Use dates where repressive forces are in place, also to bring up your campaign efforts. And being often those legal teams are a lot of the networking and coordinating roles within those campaigns. And maybe as a last thing, it's not always easy as we are faced with repression. There are different challenges. Sometimes activists come up with really unexpected ideas and behavior, and you as a legal team have to be very adaptive if you want to continue to support them. Your phone might be very well accepted by the state's official places as a police contact or another means of contact through the whole organization. Activists might be unreachable after an action or very demanding with a lot of questions and maybe exceeding your resources as a legal team. As already said, it might be really hard decision finding regarding out-of-court settlements, if you even consider it. Most of the time, lawyers are very, very busy and hard to reach, but mostly they are still great. And you always, as in, I think, every kind of political activism, you have to deal with very limited resources and see how to make the most of it. And you have those different strategies, and they even can change throughout the years. You might start with a very, very pragmatic reason and see, okay, there's still a lot of political potential in it. Yes, and I think that's then if this happens, your work has been great, but maybe there are also other things to measure your work on. What I really think is most important for me, and to also sum up here, is that as you do legal work, always keep in mind why you're doing it, what's your goal, what's your top priority, and then also go for this network approach, try to organize with people facing the same problems or reaching for the same goal. Yes.
Thank you, Zoe, so much for also shedding some light on all the work that is behind what we say as this legal teamwork. I would thank you for all the questions, for the people who showed up. It's really great to see how many people are interested in learning and sharing and organizing together to fight these repressions. We did share the TAD link in the chat with the key trends, with some more links from our panelists, the way how you can join the Legally Green network. So yeah, please take a look And we will also share that with some kind of inputs or outcomes of the webinar with the people with you who registered for this. So yeah, thanks everyone once again for joining, and continue fighting and have a great evening as well.